there. So I'm taking care of her role as well as my role also. Welcome to the last webinar in the series of masterclass on listing regulations. We have already had earlier with regard to debt listing, so we are not covering chapter 5 this time, but we have already covered chapter 2, 3, as well as 4, and we have picked up the regulations also depending upon its importance. In fact, as I let me summarize the whole thing that especially with regard to chapter 2 of the listing regulations, which are referring to the principles of corporate governance. With all due regards, in fact, after 2015, when they were enforced for the first time, very few company secretaries might have gone to chapter 2 again. My request and submission to all of you is kindly go through this at least once in 6 months, chapter 2. That is very, very important as far as the corporate governance principles are concerned. When I go as a panelist to Institute of Directors or wherever I address corporate governance seminars, I always request the people, whether you are working for a listed company or not, or you are having listed company clients or not, but do read chapter 2 of the listing regulations because it contains the principles of corporate governance. Apart from that thing that we have also covered chapter 3, which is applicable to all both equity as well as debt listed companies. Then we have taken a deep dive into chapter 4. Wherever required, we have taken only two regulations like regulation 33. We have discussed in detail. Regulation 30, we have discussed in detail. Of course, regulation 23 as a part of our RPT, masterclass, we have discussed in detail. So today we are now coming to the fag end of the masterclass on listing regulations. That is residual regulations, I may call it as. That means the remaining regulation. They are not residual as such, but the remaining residual regulations as far as our masterclass is concerned. Let me put it this way. In this 38 to 48, the most important things are your transparent transmission of securities, and similarly dividend declaration as well as dividend distribution policy, change of name of the listed company, and similarly the information what we have to put it on the website. These are a few things which are there. That of course we will discuss it. At the same point of time, as far as the transfer and transmission of securities are concerned, several company secretaries think that the securities are already in the demat mode. So the R&T agent will take care of that and I don't need to worry much about it. At one point of time, the strength of the company secretary used to be about his knowledge as far as the transfer of securities are concerned. I don't say that that strength that is not so as of now, but unfortunately, some company secretaries do think so. Especially when you work for big conglomerates and the old companies like Reliance, Tata's, Hindustan Unilever, and all these kind of companies, they do have at one point of time the entire securities in physical mode only. So when you have physical mode, lot of litigations will be there and lot of procedural formalities used to be there. But now because everything is in the demat mode, though the litigations to a large extent have been reduced, and similarly the complexities are also to a large extent have reduced, but that doesn't mean it is completely not there as such. As a company secretary, despite the fact you have an R&T agent, it is at the end of the day your responsibility if any kind of non-compliances are there, if any kind of litigations arise, all these things you have to take care of. So hence, as a company secretary, we need to have good knowledge about transfer, transmission, change of name, division, distribution of dividends, all these things are concerned also. At the same point of time, we know that the stakeholder responsibility and SRC committee is there, and this committee, its role is primarily to take care of all these things. So as a company secretary, you need to give comfort to the SRC board also. And so these are a few issues, of course, we will discuss in detail. And in addition to that, I want to make an announcement today because sometimes it so happened that the people who are there in the beginning of the webinar, by the time we are concluding it, some people are dropping out. So for the benefit of them that, let me say, next Saturday, that is 30th of December 2023, being the more or less the last leg of 2023, we are not going to have any webinar. We are taking a what's called as a week off, so that we all can enjoy the year gone by, and we can have a review of the year past and what we have done exactly. And at the same point of time, we can also plan what we are going to do for the year 2024. From 2024, I'm delighted to announce that we are going to have a new master series as far as limited liability partnerships are concerned. We have received several suggestions that when you are organizing these kind of listing regulations, why can't you organize a LLP series also? No doubt about it that, in fact, very few webinars you might have observed that where people have shown interest in the LLPs. Of late, LLPs are also again becoming a very what's called as key hot topics these days, especially when the significant beneficial ownership rules are also applicable now to LLPs. So we thought that let us also plan a 5 to 6 webinar series as far as LLPs are concerned, wherein we are going to take a deep dive into each and every aspect pertaining to LLPs. After that LLP series, we are also intending to take up a new masterclass on the Companies Act 2013, because a lot of changes have come, and we are all aware of Companies Act also, and we are discussing it in bits and pieces. So we thought, why not to have a 2024 a masterclass and the Companies Act also. These are our next, the plans we can say for next 5 to 6 months, and as and when in between, if anything, we have to have it, that also we will consider it. So with this, let me introduce that for today's webinar, we have invited Mr. Sanjay Gupta, a dear friend of mine, and when many of you might be knowing him also, he is the company secretary and chief compliance officer of IndiGo Airlines. Yes. Yeah. So, friends, sorry for the technical snag, and let me introduce Sanjay's profile, and over and above whatever his achievements are there, he is a very dear friend of mine and very well-known person in the professional circles. And Sanjay Gupta is presently working as the company secretary and chief compliance officer at IndiGo Airlines, India's leading aviation and company. And I'm sure that every participant, one time or the other, might have traveled in IndiGo, definitely. I think I have been, I read somewhere recently that IndiGo's, as far as the sector capture is concerned, almost 60 to 65% of aviation sector of India is captured by IndiGo. So he is the proud company secretary of IndiGo Airlines, and he's a fellow member of ICSI, also a member of CMA, and holds a law degree from Delhi University. And he has done his BCom honors and MCom from Shriram College of Commerce, Delhi University, a very prominent and prestigious college in Delhi. In his career spanning of about 33 years, Sanjay has, to his credit, rich and diversified experience in corporate secretarial, legal compliances, and corporate affairs with renowned and large companies and corporate groups, including he was a colleague of mine also at one point of time. He worked with Reliance Industries Limited, Chambal Fertilizers and Chemicals Limited, RP Sanjay Goenka Group, ICICI Bank, KK Birla, DCM Shriram Group, and so on and so forth. In fact, whatever I have told you about transmission, transfers, and what kind of importance and how they were strong points as far as the company secretary is concerned at one point of time, Sanjay knows these things better than me, because he got a very strong background of all these things. Because Sanjay used to handle at one point of time in both Chambal as well as at Reliance also, if I am not wrong. He has been a council member of the WRC of ICSI from 2011 to 2014 when he was in Mumbai. During this period, he has held office as chairman of various committees, including Professional Development Committee, Training and Educational Facilities Committee, Placement Committee, and Accounts and Finance Committee. And he has also been a treasurer of WRC. I'm not going to introduce neither myself nor Professor Bala, because every one of us knows us very well. And since I have already talked about the topic, now let me request Sanjay to say a few words about today's topic. After that, I request Bala to also speak on that. And then before that, Kanchan today. Kanchan is the partner of Mehta Mehta from Hyderabad. She takes care of our Hyderabad branch, and Kanchan is going to make the presentation today. And as and when we as panelists are required any kind of value addition, we will step in. Thank you. Sanjay, please take off.
Okay. So before I start, first I convey my sincere thanks to Mr. Sudhakar. I think he introduced me in so many words. And I'm really privileged and very thankful to you. I was very happy that he introduced me. So much things are not required. I only think I am serving the profession only. And secondly, Mr. Atul Mehta also is a very close friend of mine. He was in the council when I was serving the WSC council. And first of Mehta Mehta, since I am attending as a panelist for the first time for the Mehta Mehta, I think Mehta Mehta is doing a great job in imparting knowledge through webinars, through master classes, and he is serving great cause in the profession. I really like the way he's doing all these things. And what is Sudhakar? Mr. Sudhakar, I know for last 25 years. Earlier, when we were in Delhi, we both were in Delhi. He was, in charge of Delhi Study Circle when he was holding weekly, knowledge series and so many things. And many of these series I also attended. Fortunately for me, after Mr. Sudhakar joined Alliance, I was also part of Alliance. And my experience of working with Sudhakar and Mr. Sethu was really tremendous. And just 1.5 years or so in serving Alliance, I learned so much, which a person could learn in 15 years. So much knowledge is there in Alliance industry. And now coming to this topic, as Mr. Sudhakar said, that in LODR, though every topic is important, no topic is less important than the other. And I agree that chapter 2 is, fundamental thing, chapter 2, chapter 3 principles about, every person has to learn. So this last part, regulation 38 to regulation 48, these are also very important. And the role of stakeholder relationship committee mainly deals with these topics only. So every company secretary has to have, a very good amount of knowledge for these topics. And in today's company, new age companies, with all these shares are held in dematized form, because the importance of some of the topics may be undermined, like for example, shares, they are not required, and all these shares are held in dematized form. But in the earlier days, when all the shares were held in physical form, and all those companies which belong to that time, many shareholders are still in physical form only. We talk of Reliance or very Tata Group companies, though people are getting their shares converted into equity shares, but let me tell you, a large amount of shareholders are still having the shares in physical form. So for a company secretary for doing his job in a proper way or maybe in effective manner, the good amount of knowledge of all these provisions are very, very important. And in addition to transfer and transmission of securities, one topic which is regulation 38 is also very important. Like the minimum public shareholding. We all know that minimum public shareholding required is 25% in case of all private sector listed companies. And because public sector listed companies, this is 10%. But when the company goes into public, this is not that company is going for 25% public. Sometimes this so happens the company is getting listed with maybe some 10%, 12% of holding going to public, and maybe more than 85% still in the public. And in that case, it becomes very, very important to know, how in how much time the company has to bring this public holding to within 25%. Like there are various examples. One best example I can say is about IndiGo only when I joined the company. Promoter's holding was to that 87%. And the company was to bring it public holding, promoter holding to 75% so that public holding becomes 25%. And the time limit is 3 years. So there are various ways available. Knowledge of all the things also is very, very important. And secondly, in addition to transfer and transmission, record date, dividend, and the other things like the information that is to be put on the website of the company, about the newspaper publication, all these things are very, very important. For any company secretary, for doing his job effectively, the knowledge of these provisions are also very important. And the powers nowadays are delegated to RTA for doing this kind of functions. But we only have to deal with the RTA. Ultimately, if anything goes wrong, this is not the RTA. Primary liability is of the company itself only. So basically, for managing the RTA after also, your good amount of knowledge is also very important. So that if anything is not being done properly, or the compliance is not being the RTA, or they are not clear about any provision, so that any point of time, company secretary can intervene and tell and advise that this thing has to be done in this manner. You could responsibility remain yours only. So having said that, maybe I will start, request Kanchan to start that. And if any question are there, we can take the question in between or maybe after the end of presentation. Thank you so much.
Yeah, Sanjay, only one request that, in fact, I was thinking that it is only with me because you are wearing your earplugs, might be because of that your voice is not very this thing. And just try by removing earplugs, how, if you speak, how it will be. Let me also see that.
Okay, let me see.
You have to disconnect also your earplugs. You know that.
Is it? I'm audible now?
Yeah, now it is very clear, Sanjay. I'm sure that I think you don't have any issue without speaking the earplugs. I
No,
mean,
no, no, no problem.
without ear.
I'm alone in the room. There's
Yeah,
no issue.
I think now your voice is clear because one of the participant also has mentioned. That's why I thought let me do it. So, Bala, kindly take it forward. Bala,
Bala,
you're
you have to
muted.
unmute yourself.
Good morning to all of you. We have come to the fag end of the year. As Sudhakar already puts it, we are going to start with the new year. So let me wish all of you a Merry Christmas, followed by the Happy New Year. We take a fresh resolution for the new year. We'll come with the refreshed for the next year. Mr. Sudhakar and as well as Sanjay has actually stressed upon the importance of various things on the dividend policy, transmission of share, etc. The regulation 38 to 48 is basically more or less compliance oriented timeline. You have to comply with it. There is nothing beyond that. But at the same time, lot of nitty-gritties are involved. Now, I will only touch upon two topics on this, regulation 38 and regulation 48, beginning topic and the end of the topic. The 38 talks about the minimum public shareholding. In the minimum public shareholding, if you have seen the SEBI's history, there has been actually various regulation which has come on minimum public shareholding. There has been discussion because while PSU was allowed to have 10%, other people were to have to 25%. All these norms were there. In between, to bend the laws, people used to think, can the trust holding, the shareholding on behalf of the employees can be a public? Similarly, can we reclassify the promoter shareholding and the public shareholding? All these things has been there in the past. There was a discussion which was actually going on. Perhaps that is the one now SEBI has actually come out. The various norms on the public shareholding, reclassification of the shareholding of the promoters, what circumstances, what is permitted, what is not prohibited, and all those things. Leaving apart that, although the minimum public shareholding is a continual requirement, there are circumstances at times the minimum shareholding might fall. Maybe due to the open offer, maybe due to the amalgamation, all those issues which are event-based, the minimum shareholding may fall down. When the minimum shareholding may fall down, then what happens? What are the steps? How to increase upon the minimum shareholding, bring it back? What are the regulation concerned with that? What is the time limit is permitted, etc.? How we do it is another issues which we'll be discussing it. And similarly, the last topic, 48, accounting standards. The LODR simply says the accounting standards has to be complied with, etc. As you are all aware, accounting standard is not only on the LODR, it is a fundamental under the Companies Act itself. They have to comply with the accounting standards. Okay, comply with the accounting standard is one. Second thing is there, it is the responsibility of the board of directors to categorically state they are actually complying with the accounting standards. And similarly, if there are any deviation, if it is a non-compliances that taken place, any departure has taken place, it is really to be explained. Because it is not, you are not following the same system, etc. Because when the amalgamation takes place between the two companies and all, system might change. One has to adopt the other has to adopt the thing. All the things will happen. But what is required is ultimately the disclosure, the reasoning, etc., which will be required actually. And in fact, if some of you might be going through the various adjudication order, which has been actually coming out in the recent past, the MCA part of it under the company side, they are very much concerned about the compliances. Wherever the accounting standards are not complied with, they are not only taking the action against the companies, but they are also taking the action against the auditors, statutory auditors, not bringing out in their audit report and qualifying the audit, etc. All these issues are also there. So with this, these are all the things which are very, very important, because although we say the regulation is only a residual regulation, what is there, it is only a disclosure procedure. There are a lot of nitty-gritties are involved. A lot of application of the mind is actually involved. One of the things what Sudhakar and Sanjay said both on transfer and transmission of share, we cannot get absolve our responsibility by saying there is somebody is called RTA, he is doing the job. There is nothing like that. We cannot get through it. Ultimately, the responsibility lies with the company secretary. The company secretary cannot take it things lightly. So that is very sure. So with all those things, we will have to travel with Kanchan's presentation. She is going to take us regulation by regulation. As usual, you can put up your questions, your clarification. If anybody wants to talk, you can raise your hands. We can discuss. You can express your views also. So let us start. I'll ask Kanchan to take over the presentation. Over to Kanchan, please.
In fact, before Kanchan takes up, let me also say a few words about Kanchan. Kanchan is one of our senior partners in Mehta Mehta, and she's having about 12 years of professional experience. She's well known in the Hyderabad professional circles, and rather, let me put it not only in Hyderabad, led both in Andhra and Telangana regions, I can say that. And Kanchan has a good experience, and so at the same point of time, before Kanchan takes over, let me also just add one this thing to the residual regulations when we call it as. Most of the times it happens that we do give importance to the important regulations like your regulation 17, 18, 23, 37, 30, all these things, 33, we give importance to that. When the small regulations are there, we never bother for that. Most probably, if I am not wrong, from 38 to 48, the regulations. Let us also say, put on our heart, on our hand on our chest and say that, how thorough we are with these regulations. I'm sure that every one of us will stammer, especially Regulation 48. If you see the amount of information, what you have to put it on the website, if somebody goes with a fine comb, are we really putting everything what is required to be put on the website? Are we doing that? As company secretary in practice, at the same point of time, the company secretary, in service, as well as the people who are in practice, who do the secretarial audits and give the compliance certificate, secretarial compliance, annual secretarial compliance certificate, they need to go through these things very, very minutely and very thoroughly. Why I'm saying this thing is the way the regulators of late are penalizing the companies for trivial issues. And if I'm sure that some of you might have heard me on the ICSF webinar on SS1 recently, which we have done. There I have mentioned a few things like blank page in the minutes has not scored off and initialed by the chairman. Pages are serially not numbered. Chairman has not put the date after his signature with his own hand. These are such a trivial issues, and the regulators started penalizing the companies, that also not the listed public companies, but private limited companies. So let us understand the importance of compliances, especially the amount of importance what regulators are giving. The purpose of with these webinars is not only to impart the knowledge, but at the same point of time to sensitize the professionals also what kind of responsibilities, accountabilities which are in store for us. Thank you very much, and Kanchan, kindly take it forward.
As you rightly said, in one of the companies, what has happened was the minutes pages numbering. What has been done is that one of the company secretary was working there. He assigned the lower person who is there, number kar do. So what he has done, probably while numbering it, few pages he has numbered with a pencil, other pages he is numbered with a pen. As you rightly find that it's a very trivial issue actually, but when the inspection took place, the regulator has taken it very seriously. They said the numbering in the pencil is not at all acceptable because it used to be with ink numbering only, because pencil numbering can be changed. The show cause notices have been issued to the company, although they were trying to explain, etc. Nothing has actually happened. And ultimately, they have to go for the compounding of offenses and they have to pay the penalty. The regulator is looking out of this way because, as you rightly say, it is not only, we can assign the job, but at the same time, we have to also ensure the job is properly done. That is why in many companies, what you call the maker-checker policy, which is actually implemented. The job done by one person is automatically checked to the other person. Nowadays, suppose the pretext of, not having the more manpower, reduction of the things, etc. And all this, no. Doing the first time, you do it, there is no need to check. We take it very lightly. I think that we cannot overlook, especially when it comes to the compliance matter. Okay, Kanchan, you can proceed.
Very good morning, dear panelists, and everyone who is here today. Despite having, I think, a long weekend for a lot of people, we have so many people who are here eager to learn in our series. So without wasting much time, I'll directly get into our presentation for today. Is it visible, sir?
Yeah, very much.
Yes.
Yes, sir. So, so today's topic that we are dealing with on is the masterclass on SEBI LODR residual regulations. That is, we would be covering regulation 38 to 48, which are covered as in the chapter 4. So just to briefly pen down the regulations, what they are, I have just mentioned that we are going to deal with the minimum public shareholding, issuance of certificates and letters, advices for securities, dealing with unclaimed securities, what will be the procedure in dealing with them, then transfer, transmission and transposition of securities, some other provisions are related to the securities, record date, dividends, and meeting of the shareholders in voting, change in name of listed entity, what all needs to be mentioned on the website. Briefly, we'll be covering these aspects. Then what kind of advertisements, which are the situations where advertisements needs to be given in the newspapers, and how much of accounting standards and the consonance with the Companies Act that a company needs to follow. What is the relation between the LODR and the Companies Act when it comes to following the accounting standards? This is briefly the walkthrough of the presentation. So the first regulation that we are talking about today is minimum public shareholding, regulation 38. So the listed entity shall comply with the minimum public shareholding requirements, which is as specified in Rule 19.2 and Rule 19A of Securities Contract Regulation Rules 1957 in the manner as specified by the board from time to time. So we briefly talk about the Rule 19.2, which states, apart from complying with any other terms and conditions as may be laid down by the recognized stock exchange, an applicant shall satisfy the stock exchange that the company's articles of association provide that the company needs to use a common form of transfer, and the shares need to be fully paid. They need to be without lien. There cannot be any forfeiture of unclaimed dividends. So the articles of association need to provide for it. And it also talks about the minimum public shareholding to be at least 25% of each class or kind of equity shares or debentures which are convertible into equity shares issued by the company. It was offered and allotted to public in terms of an offer document, or at least 10% of each class or kind of equity shares or debenture convertible equity shares issued by the company was offered and allotted to public in terms of an offer document if the post-issue capital size is more than, if the post-issue capital price goes beyond 4,000 crore rupees. So this is briefly what the regulation, the Rule 19.2 of Securities Contract Regulation Rules 1957 talks about. And these provisions have also an exception, which is it does not apply to the entities which are listed on institutional trading platform without making a public issue. So let us briefly understand what is the time limit for achieving the minimum public shareholding that we've just discussed. So every listed company other than public sector company shall maintain a public shareholding of at least 25%. Any listed company which has public shareholding below 25% on the commencement of Securities Contract Regulations Rules 2014, it shall increase it within a period of 3 years from the date of such commencement in the manner specified by SEBI, and it shall also maintain it at this level going forward. So if the public shareholding falls below 25% at any time, such company shall bring it back to 25% within a maximum time period of 12 months from the date of such fall. So what if the fall happens, and then what is the manner of achieving the minimum public shareholding then?
Kanchan,
So SEBI...
Kanchan, when you are saying fall happens, what are the circumstances in which the fall can happen?
Right. So
I think Sanjay could share his practical things on this, because I think he has dealt with this on this.
Yeah. See, there are two things. One, when the companies has already explained, when the market cap is going to be more than 4,000 crore at the offer price in case the company is going out to public. In that case, company can be allowed to offer up to 10% of the maybe 10% of public holding, and promoter holding can still be 90%. In that case, the company are given 3 years per time period to bring the public holding to 25% and maybe reducing the public holding. So there are various methods which are given the second part of the slide, that which are the various methods the company can adopt to bring the public holding to 25%. This can issue new shares to or it can be offered for sale by the promoters. This can be issued placement route. So there's various other things also. Various methods are there. Second thing is that the continuous listing requirement. When the company is already listed and the public holding is maintained 20-25%, so there can be some circumstances when the public holding can fall below 25%. One of them is open offer. We all know that under SEBI SEST regulation, when under certain circumstances, open offer has to be given to all the public shareholders of the company. So as a result of open offer, this is sometimes possible. The public holding can come below 25. That means the promoter holding can go beyond 75%. In that case, there is a stipulation that companies are given 12 months time period to bring the public holding to 25%. And the methods which can adopted are same, which are already mentioned in the second part of the slide. Mr. Balakrishnan, would you like to add anything?
Sanjay, it is also true that some of the companies actually, for the purpose of delisting the company,
yes,
they adopt the method of offering the buyback or open offer, etc., and all these things. When the minimum shareholding level comes down, rather than increasing the shareholding, they straight away go for the delisting process.
No, that is clear, because the delisting is a separate purpose. In case of delisting, there's separate mechanism which is provided when the promoters can go over buyback thing and gradually reduce the public shareholding part, and by that they can do it. So in those cases, because the delisting is a separate provision, the purpose is to delist. So in that case, that is, and the continuous listing requirement is for the company which are going to remain listed. If the ultimate purpose is go for delisting, then there's no question of holding the public holding level at 25%. So separate mechanism provide for that also. The companies can adopt that. So in that case, I don't think that minimum public holding is required to maintain.
Yeah, that is right. If you are going for the delisting, it's altogether a different issue. Yeah.
Yeah, that's a different issue.
Yes, Kanchan.
Yes, sir. So, as discussed by the panelists, these are the few methods that we are looking at, which are used by the companies as approved by SEBI for achieving the minimum public shareholding. So, issue of shares to public through prospectus, offer for sale of shares held by the promoters through prospectus, then sale of shares held by promoters through secondary market, institutional placement program in terms of Chapter 8A of SEBI ICDR Regulations 2009, rights issue, bonus issue. So these are the few methods. And I think also, sir, maybe we could also throw some light on the relatively newer methods like the QIP placements and the ESOPs also that are getting issued to achieve this minimum public shareholding.
Yeah, as you rightly say, some companies are doing it through the ESOP method as well. But of course, ESOP has to comply with the regulations which are applicable. Yeah.
Yes, sir.
See, primarily, let me add a few things. Then, primarily, the public shareholding comes down whenever there is a kind of a corporate restructuring. That means, say, for example, the companies might be ailing, and the promoter has to invest the funds. And that point of time, what happens is that similarly takeover, when the takeover takes place, these are a few instances where the promoter shareholding goes up and the public shareholding comes down. So whenever these kind of proposals, when SEBI is approving it, they give a sufficient time to the promoter to ensure that public shareholding is restored, the 25%. And if by any chance, if it is not done, the companies will be penalized accordingly also. And there are certain ways and means are there by which you can ensure that public shareholding is to be increased. if and sometimes that they may bring some issues and that follow on public issues, something like that, where promoters will not participate. So just go back to the previous slide, Kanchan. Similarly, bonus issues where promoters may not be participating, rights issues where promoters are not participating. So that what will happen is the promoter's shareholding will be intact and public shareholding in turn will be increased. That's how you have to restore it to the 25%, 75%. Sometimes it may so also happen that instead of bringing a fresh issue without increasing the capital, the promoter may also offload some of his stake in the market, which that the public can pick it up. So these are a few, the methodologies. At the end of the day, if the promoter don't want to delist the shares, if he wants to continue to be as a listed entity, he has to ensure that 25% public participation is very much there.
Yes, sir. So moving ahead, we also have penal action for non-compliance with minimum shareholding requirements, which is as there is an imposition of fine of rupees 5,000 per day of non-compliance on the listed entity till the date of compliance. This it would continue. The stock exchange shall intimate the depositories to freeze the entire shareholding of the promoter and promoter group in such non-compliant listed entity till the date of compliance. In some cases, we also see that there could be delisting of the companies if such kind of compliance is not adhered to. So moving on to regulation 39, which talks about issuance of certificates or receipts, letters, advices for securities and dealing with unclaimed securities. So the listed entity shall comply with Rule 19.3 of Securities Contract Regulation Rules 1957 in respect of letters or advices of allotment, acceptance or rights, transfer, subdivision, consolidation, renewal, exchanges, issuance of duplicates thereof, or any other purpose. So the listed entity shall give effect to the issuance of the certificates or receipts or advices as applicable for subdivision or split, consolidation, renewal, exchanges, endorsements, or issuance of new certificates in any case of loss or worn out certificates or receipts or advices in a demat form within a period of 30 days from the date of such lodgement. So the listed entity, it shall submit this information regarding loss of share certificates or issuance of duplicate certificates to the stock exchanges within 2 days of getting the information. So the listed entity shall comply with the procedural requirements which are specified in Schedule 6 while dealing with securities issued pursuant to the public issue or any other issue, physical or otherwise, which remains unclaimed or they are lying in the escrow account as applicable. So here we briefly just talk about Schedule 6, which deals with the manner of dealing with unclaimed shares. So the listed entity, it may delegate the following procedural requirements to a share transfer agent, in which case periodical reminders need to be sent. So the listed entity shall send at least 3 reminders at the address mentioned below. For shares in physical form, they need to be sent to the address given in the application form, as well as last available address as per the listed entity's record. For shares in demat form, reminders need to be sent to the address captured in depositories database or address given in the application form if it was a physical application. Moving ahead to Regulation 40, which talks briefly about transfer or transmission or transposition of securities. So this regulation briefly states that unless the securities are held in dematerialized form with a depository, requests for effecting the transfer of securities, it shall not be processed. So the board of directors of a listed entity, they may delegate the power of transfer of securities to a committee or a compliance officer or to the registrar to an issue or share transfer agent who shall attend to the formalities of such transfers at least once in a fortnight and report on the transfer of securities to the board at each board meeting. So on receipt of proper documentation, the listed entity shall register the transfer of its securities in the name of the transferee or transferees and issue the certificates or receipts or advices or issue any valid objection or intimation to the transferee or transferor within a period of 15 days from the date of such receipt of request or transfer, provided that the listed entity shall ensure that the transmission requests are processed within 7 days after receipt of the specified documents.
So, Kanchan, here I would like to add anything. The first bulleted point is very important. That in case of until the securities are held in demutualized form, the transfer request shall not be entertained. Friends, this provision was introduced by SEBI. I don't exactly remember. This happened about maybe 2 years back or so, when this was made mandatory that no transfer of shares will be entertained by the company unless the securities are held in demutualized form. Because this was to encourage the holding to be held in demutualized form only. Because what happened in case of companies like Airlines Industries, so many other companies, where the large number of shareholders are still holding their shares in physical form only, and they think since we don't have to do anything, and we do not pay charges to the depositories, all the things, what's wrong? Let's continue to hold the shares in demat form, physical form only. So after this was made mandatory, so this was very necessary for the people who were having the shares to get the share dematerialized, because until the shares are dematerialized, the shares cannot even be transferred also. Because earlier, the dematerialization was mandatory only when you are going to sell the shares in the market, because that provision came a long time back. Like for doing any selling of the shares or any transaction in shares, the shareholding has to be held in dematerialized form only. But the transfer was still possible in the physical form. Like if A wants to transfer the shares to B, I can do that. There's nothing wrong. I can do in physical form. This thing was made mandatory. The transfer also will not be permitted. I think that was a very revolutionary step. And due to that thing only, a large number of shareholders bought their shares dematerialized. But secondly, about the transmission and transposition, you can still hold your shares in physical form. But in case you want to get it transposed, like from ABC to BCA or any order, or the shares are transmitted. So this is mandatory for the company. After effecting transposition or transmission, the shares will be issued in dematerialized form. So before sending any such request, you have to open a demat account and share the details with the with the company or with the RTA. So I mean, these things are very, very important steps. Mr. Sudhakar, would like to add anything? I think you also.
Yeah. See, these provisions to a large extent these days have been extended under the Companies Act also, and that also till recently it was applicable to public companies. Now it is equally applicable to private companies also. As far as the dematting provisions are concerned, unless until they are dematted, you cannot affect the transfers and all. You cannot issue the further securities in physical mode. So all those issues that. At the same point of time, one thing I would like to draw the attention is that the board may delegate its power of transfer of securities to the compliance officer or to the registrar and that R&T agent of yours. So in most of the times it happens that companies definitely nowadays in-house transfers are very sparingly happening. Most of the times everyone is given to the R&T agents only. So it is the responsibility of the company secretaries to ensure a proper MIS system on weekly basis, fortnightly basis, because most of the times it is the compliance officer who is also the compliance officer. Sorry, the company secretary is the compliance officer under the PIT regulations. That is prohibition of insider trading regulations. So it is his responsibility to ensure that the compliances of PIT regulations is also in place, for which he has to have proper MIS system from the R&T agent, so that he will come to know what kind of transfers are taking place and what sort of the compliances, whether the designated persons have made or not. All this, for these issues, he should have a weekly Ben Post download when it's happening on Fridays. He should ensure that by the morning of Saturday or morning by latest by Monday, he should have the things in his place. At the same point of time, if you also see that the information is to be placed before the board at its next meeting. So every board agenda should have one item definitely pertaining to the MIS relating to the transfer, transmission, issue of duplicate certificates. All this MIS from the R&T agent is also to be placed before the. So when we are having minimal 4 board meeting that is on quarterly basis, exceptional meetings may be there, but you don't need to make this place before the board for every meeting, but even in that 4 quarterly board meetings, if it takes place, that is sufficient enough as such. But that should not be forgotten. Okay, that is also one of the compliances. And another thing I would like to draw the attention of the participants is if you see in the regulations, most of the time the word used is shall. Even in the regulation 38 to 48, which we are calling for our purpose of the webinar as residual regulations, there also everywhere the word used is shall, and shall we know the importance of that word. So ensure that each and every smallest of the smallest compliance, if it is not done, it will lead to a non-compliance and the consequences will be followed. Thank you. Yes, Kanchan, go ahead.
Yes, sir. So the listed entity.
Sudhakar, can I say, here the regulation says actually, if the transfer, transmission are to be affected, then it need to be the dematerialized form. There are very old companies who are parent company shares are held in the static form, they do nothing. There is no transaction, nothing, it continues, keep ever. They can still hold the share in the physical form, so long as transfer is not taking
that
place.
only it is mandatory for the promoters to have it in the demat mode. Other than the promoters, the remaining public is concerned, they can continue to have in the physical mode. But you will not be able to effect any kind of transfer of those securities. In the same point of time, God forbids, in case of the death of the shareholder, when the transmission has to take place to his successors, that transmission will not happen in physical mode. So you can continue to have the share certificates. Whoever is the shareholder, he can continue to have it in the physical mode till the time he is alive.
So I also want to add one more point. I mean, there's a confusing language in the regulation. When it says that transfer has to happen only in dematerialized form. Because when the transfer is happening in dematerialized form, company is not required to do anything. A and B are holding shares in dematerialized form. So transfer takes place for the market mechanism only. This is only in case of offline transfer, when the transfer can happen from A to B directly. Otherwise, if you are selling the shares in the market, the identification of the transfer and transferee are not known, and company has no intervention at all. So in case of dematerialized form, the word transfer is, I think, confusing.
See, in case of demat, whenever the shares are transfer is taking place, there is no question of any intervention of the company as such.
Yes.
Companies has to effect the transfer only in case of physical mode it is there.
Yes.
So even the physical share transfers, even if the sale purchase is happening off market, still those transfers have to come to the company to get affected. At that point of time, company will not be able to register that transfer unless until the shares are in physical mode.
Yes.
Okay.
Somebody is asking, putting up a question. Is there any benefit to the holder of the security in the physical form?
See, people still are paranoid about the things, anything is in the electronic. Something in my hand is always secured than something which is not in my hands. That is the belief of some people. But the answer to that is, when you open a bank account, your money is in the bank, not in your hands. That was, in fact, when the demat things had started in the somewhere, I think in the mid 90s. The answer that everybody was worried about, that the moment I convert my certificates into a demat mode, I may lose my control on that. The answer to that is, are you having the money in whatever you are putting in your bank in your hands? That was the answer for that. At the same point of time, we need to have checks and balances. Whenever you are having a demat account and having your shares, from time to time, you need to log into your account, check your balances, whatever it is there, the way you are checking your balance, the bank account. Now, question comes that when people will be having, why people prefer to have this thing. Nowadays, I don't think even 1% of the shareholder community is having that kind of things. But yes, in case of Reliance, I know that there are some people who are passionate about having the share certificate signed by Dhirubhai Ambani. So they say that we won't convert that particular physical distance. It is a kind of a what's called as a signature trophy or something like that. Same is the case with Tata companies. Suppose whether it is Mr. J.R.D. Tata might have signed a certificate or in the initial days. Of course, now of late nobody is signing that. But yes, there at one point of time when Mr. Dhirubhai Ambani has signed the certificates physically, those were also there with some people. So they think that these are like, as I told you, signature trophies. They want to keep it with them. They may not even sell that shares and all that. We don't know.
You are right, actually, Sudhakar, on the writer side. We want to see the physical copy of share certificate with the company logo and the people signed over it.
Yeah. So, Mr. Balakrishnan, I also like to add something because since in my earlier days as company secretary, I also dealt with a lot of physical things and all. So, I have seen, as Mr. Sudhakar said, maybe this is only 1%, 2% of the people who are still holding the shares in demat, so in physical form only instead of demat. And as per the regulatory requirement, if you want to sell the shares, you have to have demat account only. So this depends on mindset only, because what happens when your demat account? Demat account, you cannot sleep for a long time. You have to have the KYC formality also being done from time to time. You have to pay some demat charges also to the DP. Some people who have a fundamental belief in the company for a long time, and they think they are not going to sell the shares for maybe for next 5 years, 10 years. So that class of people, maybe some people would still like to hold the shares in physical form, and they think whenever I have to sell the shares, at the time I'll get it dematerialized. What's the need now actually? So this is just the mindset only, nothing else.
Sudhakar, one more thing.
In fact, sometimes people think that by having physical certificates, I am secured. In fact, that is also again a false impression that by having physical certificates, you are secured, because already there are some scamsters got duplicate certificates issued by forging your signatures. They got it dematted and then they have also sold it in the market. In fact, when I was in the Reliance, several instances have come to our notice, and we were having equally matching signatures, entire supporting documents. As far as the share transfers are concerned, for issue of duplicate certificates are concerned, these are all there. Sometimes people might be ignorant that thinking that, okay, my money is secured. But unless until you are vigilant enough, these kind of frauds do take place. So better to have converted your physical shares into demat mode, because in demat mode, the chances of fraud is very, very less in comparison to the physical mode share transfers.
Sudhakar, without naming anybody, you may be also aware, when you talk about the physical share scam, there are particular people who are based at Calcutta. They were actually identifying the good companies where the shares are there. They have already forged the share and they have sold in the market. They have launched the company against the false claim, etc., saying all the things. All the things that happen. There are a lot of companies actually face a problem on that.
Yes, Kanchan, go ahead.
Yes, sir. So the listed entity, it shall not register the transfer when any statutory prohibition or a prohibitory order of a competent authority restrains it from doing so, or when the transferor objects to it. So these are the exceptions where the listed entity cannot register for the transfer. The listed entity shall not decline to register or acknowledge any transfer of shares if the transferor or the transferors who are joint holders, they are indebted to the listed entity. The listed entity to comply with Schedule 7 with respect to transfer or transmission of securities. And the listed entity to complete the transfer of securities within 15 days or communicate a valid objection within the time, failing which the listed entity shall compensate the aggrieved party for the loss that they would have suffered. The listed entity shall ensure that the share transfer agent produces a certificate from a practicing company secretary within 30 days from the end of financial year, certifying that all certificates have been issued within 30 days of the date of lodgement for transfers or subdivision, consolidation, renewal, exchange or endorsement of calls, allotment monies, and this certificate needs to be filed with the stock exchange simultaneously. So in addition to the transfer of securities, this provision also, the provisions of this regulation, it shall also apply to deletion of name of the deceased holders of securities,
of something that you put in there.
Transmission of securities to the legal heir, transposition of securities where there is a change in the order of names in which the physical securities are held jointly in the names of two or more holders of securities. So moving ahead, some of the other provisions relating to securities. So the listed entity, it shall not exercise a lien on its fully paid shares, and that in respect of partly paid shares, it shall not exercise any lien except in respect of monies called or payable at a fixed time in respect of such shares. So the listed entity, it shall, in case of any amount to be paid in advance of calls on any shares, stipulate that such amount may carry interest, but shall not in respect thereof confer a right to dividend or to participate in profits. The listed entity, it shall not issue shares in any manner that may confer on any person superior or inferior rights as to dividends vis-a-vis the rights on equity shares that are already listed. So the listed entity, it shall issue or offer in the first instance all shares, including the forfeited shares, securities, rights, privileges, and benefits to subscribe pro rata basis to the equity shareholders of the listed company, listed entity, unless the shareholders in the general meeting, they otherwise decide. So unless the terms of the issue otherwise provide, the listed entity, it shall not select any of its listed securities for redemption, otherwise on pro rata basis or by lot. So moving on, we go to regulation 42, which talks about a record date or closure of transfer books. So the listed entity, it shall intimate the record date for declaration of dividend, issue of rights or bonus shares, issue of shares for conversion of debentures or any other convertible security, shares arising out of rights attached to debentures or any other convertible security, corporate actions like mergers, demergers, splits, etc. Other such purposes as may be specified by the stock exchange. The listed entity shall give notice in advance of at least 7 working days, excluding the date of intimation and the record date, at least 7 working days to the stock exchange of record date, specifying the purpose of the record date, provided that in case of rights issues, the listed entity shall give notice in advance of at least 3 working days. So the listed entity shall recommend or declare all dividend or cash bonuses at least 5 working days, 5 working days before the record date for the purpose. So the time gap needs to be maintained of at least 30 days between 2 record dates. And for securities which are held in physical form, the listed entity may announce the dates of closure of its transfer books in place of record date for complying with the requirements specified in the regulations 1 to 4 here. Sir, you're on mute, sir.
I was asking, is there any significance today in case of the closure of the transfer books? Because this was good at the time when the physical shares were actually transferred by the companies. You know, this was actually working at that particular time. Now, everything on being a demat, it is only a record date. Is there any significance on this?
So, Mr. Balakrishnan, let me respond to your question.
Sanjay, sir, I request you to be a little more audible. I think the voice is...
Yeah, some voice is a problem.
Am I audible clearly now?
Yeah.
Yes, sir. No.
Okay. So, I was saying that I agree with your point. You know, in the today's time, especially the companies who have issued, went for IPO in last 10 to 15 years. So most of the shares are held in demat form only, and there are hardly any shareholder who holds the shares in physical mode. This can be the earlier promoters, sorry, not promoters, some earlier pre-issue shareholders, or maybe the people who have got their shares dematerialized. So in that case, there is no significance of a book closure. This is only record date. But what happens in case of those companies also, there's still maybe one or two or a few shareholders only who are still holding their shares in the physical form. So for physical shares, the significance of book closure date is still there. That's why companies still go for book closure. Otherwise, there's no significance of book closure as such. This is only record date. But this is customary for the company, at least at the time of AGM, to go for book closure. This is just a period of 7 days or so, book closure is maintained. So during that activity, the things will not happen, at least through market.
See, in case of listed companies under the erstwhile listing listing agreement, as per that, the closure of share transfer books was mandatory. Once in a year, you have to close it. That's why whether the requirement is there or not there, but companies used to close the books. Post SEBI listing regulations, that requirement is no more there. It is not mandatory now for the companies to close its share transfer books. So for listed companies, record date would be sufficient, not required to be close the share transfer books as such. Number one. Number two, especially now when all the share transfers, everything is happening in the demat mode, it is mandatory. So where is the question of any physical transfers? Unless until there is a physical transfer, there is no question of any requirement for closing the transfer books. At the same point of time, that earlier, even under the Companies Act, that this requirement was there, but now slowly they are also moving into the demat mandatory demat mode. So slowly and steadily, I think this closure of the share transfer books are concerned that may soon also may not be there in the Companies Act also. Yeah.
Yeah, move ahead.
So moving on to Regulation 43, which talks about dividends. So the listed entity shall declare and disclose the dividend on per share basis only, and the listed entity shall not forfeit the unclaimed dividends before the claim becomes barred by law. And then briefly, Regulation 43A talks about dividend distribution policy and what the policy shall contain. So the top 1,000 listed entities based on market cap calculated as on 31st of March of every financial year. So these entities shall formulate a dividend distribution policy which shall be disclosed on the website of the listed entity, and a web link shall also be provided in their annual reports. So dividend distribution policy shall include the following parameters. It shall include the circumstances under which the shareholders of the listed entities may or may not expect dividend. The financial parameters that shall be considered while declaring dividend. Internal and external factors that shall be considered for declaration of dividend. Policy as to how the retained earnings shall be utilized. And parameters that shall be adopted with regard to various classes of shares. The listed entities other than those specified in subregulation 1 of this regulation may disclose their dividend distribution policies on a voluntary basis on their websites. So maybe you could highlight the importance of dividend distribution policy.
See that in fact it is not mandatory for the boards to declare dividend, that every one of us knows about that. Sometimes it may so happen the company is into good profits, but still they are not declaring any dividend, or even if at all they are declaring dividend, even then they are declaring very minuscule dividend. Suppose, for example, the shareholders are expecting 20-30%, whereas the company is giving 5-10% kind of thing. So there is always a kind of uncertainty as far as dividend is concerned. So SEBI felt that the shareholders should have a clear-cut understanding as far as the dividend distribution policy of the companies are concerned. So for the first time, it was introduced with this concept of having dividend distribution policy, wherein a reasonable guidelines are to be given to the shareholders so that they can understand that. Because if you are not having that, because several people, especially in case of senior citizens, what they do is their retirement proceeds and all, they may invest in good companies with an expectation that either they may, they invest in the debt securities with an anticipation of interest, and with a, when they invest in the equity securities with an anticipation of some kind of a dividend as well as the capital appreciation. If the dividend is not coming altogether, then there will be a kind of an issue as far as the revenue flow is concerned. So that is the reason actually why it was mandated for this top 1,000 listed entities to give a reasonably guidelines, so that the shareholders can have some kind of an understanding as far as the dividend mindset of the companies are concerned. And at the same point of time, they have to also put it on their website, as well as they have to also give it in their annual report, so that the shareholders will be go through that from time to time also.
I would also like to add something here. That dividend distribution policy becomes important to the shareholders just to get to know the mindset of the company as far as dividends are concerned. Because the objective of making investment into equity shares of the company for different shareholders can be different. Some people do invest only for the purpose of capital gain, because earning dividend is not their objective. And there can be second set of shareholders who invest into a company for the recurring income like dividend. For example, in case of public sector companies, you see the dividend payout ratio is quite high. In case of private sector companies, some companies do pay very nominal dividend when you compare with the market price of the shares of the company. So any person who is a prospective investor, or for the existing investor also, this is very, very, very important to know as to what is the dividend distribution policy of the company, so that shareholder can make a decision as to whether to make investment in that company or not, if his purpose is to gather dividend from the company. And secondly, for the company also, company can also decide, even they are allowed to make an exception to the dividend distribution policy. For example, they have decided that this much percentage of the retained earning they will distribute as dividend. But in a particular year, this is important for the company to make use that retained earning for the purpose of diversification or for growth actually. So they can make it very clear, and to the shareholders that dividend has not been declared to that purpose only. So from that point of view, dividend distribution policy is very, very important actually for the prospective shareholders of the company. You can go.
Yes, sir. So moving on to Regulation 44, which talks about meetings of shareholders and voting. The listed entity shall provide the facility of remote e-voting to its shareholders in respect of all shareholders' resolutions. The e-voting facility to be provided to shareholders in terms of subregulation 1, it shall be provided in compliance with the conditions specified under the company's Management and Administration Rules 2014 or any amendments made thereto. The listed entity shall submit to the stock exchange within 2 working days of conclusion of its general meeting details regarding the voting results in the format which is specified by the board. The listed entity shall send proxy forms to the holders of securities in all cases, mentioning that a holder may vote either for or against each resolution. The top 100 listed entities by market cap, as determined on 31st of March of every financial year, they shall hold their annual general meetings within a period of 5 months from the date of closing of the financial year. The top 100 listed entities shall provide a one-way live webcast of the proceedings of the annual general meetings as well.
In case of the point number 4, when you are saying, the listed entities shall send the proxy form to the holder securities, in case of mentioning that the holder may vote either in the things, I think that is only relevance in case of the physically attended meeting, not in case of the, video conference meeting. Yeah.
Yes, sir. So the corona has brought about the changes.
Yeah, that is true. But for the last 2-3 years, the corona which has been there, all the meetings are happening only through the video conferencing.
Right.
So as far as the proxy is concerned, video conferencing, it has no relevance. But the physical board is concerned, yes, as you are saying, it's correct.
Sir, in fact, see, even if in the video conference meetings also, you cannot rule out the proxy altogether. In the notice, you have to clearly mention that because of the meeting is being held only in a virtual mode, the proxies provisions have been nullified as per the circular so and so and all. That note is to be given. You cannot just ignore that altogether. In fact, proxy appointment and giving a proxy it is a right of that shareholder as per the Companies Act. In fact, that is one of the reason in the Secretarial Standard 1 also, SS2, though you can convene the meetings at a shorter notice with the consent of 95% of the members of the company, but still you cannot hold the meeting on the same date. You have to hold the meeting only after 48 hours, because the remaining 5% of the people who are not given their consent, they have to be provided with an opportunity to exercise their appointment of proxy right is concerned. So that's why in the SS2 we clarified that very clearly. In case you want to hold the general meeting of the shareholders on the very same date, you have to ensure that 100% acceptance for holding that meeting at a short notice is there. If it is so, then yes, proxy provisions are not need to be complied with. Otherwise, they have to be complied with. So appointment of proxies is a very important aspect as far as the listing regulations and the Companies Act is concerned.
And
Yeah, you have brought up the very valid point, Sudhakar. Especially when you are having more than 95% remaining 5%. Yeah, it's a very valid point. Yeah.
In fact, if the people know that thing, most of the may not even be knowing. SS1, when we came with in the beginning itself, that it was revised from 1st October 2017. In fact, if you see in the SS2 first time, there it said this particular aspect has not been clearly brought in. When we were revising SS2, that point of time, ministry said that you please clarify this particular point. You cannot hold the meeting on the same day at a shorter notice with 95% consent. If you want to hold it, you have to have 100% consent. That's why you will find this in the revised guidance note of SS2 very clearly, this aspect.
And there's only one point I would like to add. The point number 6 on the slide. So in case the meeting is being held through video conference.
Somehow we are having a problem with your audio. I don't know.
I don't know why this is happening. Okay, let me try to change.
Yeah, your audio is very feeble, Sanjay. Anyway, doesn't matter. Just speak a bit loud. That's it.
Yeah.
Come closer to your laptop and speak a bit loud.
So I have just changed the microphone option. Let me see if this works. Am I clearly audible now or not?
Yeah. Now
it is better.
Much better.
Okay. This is just technology, nothing else.
Okay. Yeah.
So, Kanchan, I am on the slide number 6. So, in case the meeting is being held through video conferencing only, even the point number 6 is not applicable, because that is applicable only in case the meeting is being held through physical mode. Then one day live telecast has to be provided. But if the meeting is being held through video conferencing only, then this figure is not applicable.
Sir, I think we can also take up a couple of questions which have come up, I think.
I don't think there is any questions are there actually.
Okay.
Because I think is there any benefit of the holder security physical form that we actually talked about it? And then record date, somebody said, but I said record date we are not discussing because we have talked about the book closure only. That's all. I don't think there is any other questions are there. Yeah.
So moving on to Regulation 45, which talks about change in the name of the listed entity. So the listed entity shall be allowed to change its name subject to a time period of at least 1 year has elapsed from the last name change, and at least 50% of the total revenue in the preceding 1 year period has been accounted for by the new activity suggested by the new name, or the amount invested in the new activity or the project is at least 50% of the assets of the listed entity. Provided that if any listed entity has changed its activities which are not reflected in its name, then it shall change its name in line with its activities within a period of 6 months from the change of activities in compliance of provisions as applicable to change of name prescribed under the Companies Act 2013. On satisfaction of the conditions at Subregulation 1, The listed entity shall file an application for name availability with ROC, and upon compliance with the conditions for change of name as laid down in Companies Act 2013 and the rules made thereunder, the listed entity in the explanatory statement to the notice seeking shareholders' approval for change in name shall include a certificate from the practicing chartered accountant stating compliance with conditions provided in subregulation 1.
In fact, this is a very good provision which has been brought in the SEBI listing regulations. Prior to that, this kind of mandatory provisions were not there for change of name name of the company. So several times it used to happen in the past, especially in the late 90s and early 2000, that companies used to come with public issues. That point of time, they used to project one sort of a business and the name was linked with the business. And subsequently, what happened was they used to change the business line, but without changing the name of the company. So people used to get sometimes deceived as well as sometimes confused also to what exactly is the company doing. Because with the name of the company is something and the company is doing something else. So because there were no restrictions as such, except that, as per the Ministry of Corporate Affairs, that name should be available. If it is available, you can just change the name of the company with the approval of the shareholders, of course. But now what happened is on the SEBI listing regulations, they have clearly brought in that, number one, after the IPO for full 1 year, you cannot change the name of the company. And after that also, if you want to going to change the name of the company, 50% of your turnover should be from that particular business in which you are going to change the name of the company. Or alternately, you have to commit your 50% of your assets for that particular purpose. So according to me, these are the good deterrent points as far as the change in the name of the companies are concerned. Earlier, some kind of, some promoters with some malevolent intentions used to deceive the public, and this has eradicated that kind of actions.
And one more point, as Mr. Sudhakar pointed out, the condition which are to comply with for change of name. But for me, the provision which is given to subregulation 1 also is very important, because so far we knew the provision about the condition which have to comply with for changing the name of the company. That means option to the company. But when you see the provision, this is mandatory for the company to change its name if it's changed the activity altogether. So there's no more option to the company, in fact. This is also very, very important. Company has to ensure that the purpose for which funds were raised from the public, they are doing the same purpose only. And in case they are significantly changing its activities, so they are bound to change their name.
So moving ahead to Regulation 46, which talks about website. So the listed entity shall maintain a functional website containing the basic information about the listed entity, and the listed entity shall disseminate the information on aspects like details of the business, terms and conditions of appointment of independent directors, various codes of conduct for board of directors and senior management. It shall include the important policies and codes that the entity follows, and it shall include all sort of financial information, including notices, financial results, annual report, shareholding pattern, any kind of calls with the institutional investors, analysts. So I think it's a very in-depth provision which talks about, it's like a mirror for the public at large to understand each and everything in detail about the company.
Just to add here that though Kanchan has not written down that the big laundry list is there for the information what you have to put on the website of the company. One caution what the compliance officer and the company secretaries of the listed entities have to take care is that any information which you have put it on the website, it should be preserved on the website as per the archival policy of the company at the same point of time for a minimum period of 5 years. So it should not happen that most of the times it so happens that company secretaries are not involved as far as the website maintenance is concerned. Most of the time it is assigned to the corporate communications or the admin departments or something like that. So in fact, when the SEBI listing regulations were enforced, and whenever on that time when I was addressing several forums, I used to say that the company secretaries have to put a mandate as far as the website is concerned. Any item before you are deleting it, you should take the approval of the company secretary. Otherwise, without his approval, no removal of any kind of information from the website to happen. And that is still there as it is, because whatever the information you are uploading it, if you say that it is to be maintained for a period of 5 years minimum, if I am not wrong, at the same point of time, as per the archival policy of the company. Sometimes it may so happen, and as per the archival policy of the company might have prescribed to preserve the information for more period of time, in a much longer period of time than what is mandated for.
So one more thing I want to add. If you see 46, so since there is a long laundry list of the items which are to put on the website of the company under listing regulations. So this provides a ready checklist also ready right now about the items to maintain. And as Mr. Sudhakar said, that though in many companies this the website administration is in the hands of either IT department or some other department, but this is very important for us to know that which are the items. And I know one live example when the website designing was changed and accidentally some items were deleted from the website. So this becomes important for the company secretary. So whenever any such activity happens about changing website design or any realignment of the things, just to make sure that everything which is required to be maintained at the website continues to be there, and if anything is missing, just to make sure to reinstate those things on the website of the company. Otherwise, we are held responsible for the compliance.
And if I am not wrong, I think whatever the information you have to put it, maximum time period available to you is 48 hours, and minimum is as per the, as per the regulations wherever it is prescribed.
Yeah.
But one thing is there, sometimes people ask a question that whether it is under the Companies Act, whether it is under the listing regulations, and the time period is not mentioned. So within how much time we have to do that? According to me, the interpretation should be that where time period is not mentioned means should be done immediately. That is how we have to take care of that thing. Time period not mentioned means immediately. It's not like that, as and you feel convenient or as and when you feel like to do that. It is not so. So if it is 48 hours, they have said, okay, you got that means you have a leverage of 48 hours. If it is not so, it should be online basis. That's how it is to be taken. And as far as the website is concerned, the objective of the uploading the information on the website is nothing but for dissemination of the information for the public. And which is equally important, because the information what you are disseminating to the public, apart from the stock exchanges, it is the responsibility of the company to disseminate it on its website also. So if you say that I will put it on the 48th hour, it will not be acceptable. It should be done immediately. Okay. But if you give it to the stock exchanges, why can't we do it simultaneously on our website also?
Yeah, that is what it is expected actually, because it has to be simultaneous. In fact, not under the LODR, but under the adjudication of the MCA rules. Some of the notices which have been not put in the website, as you rightly say, they followed that 48 hours and other things and all these things. Information has gone out to the public, but it was delayed in the website. They take the serious actions.
In
So
fact, at one point of time, people, what they used to do is they used to upload the information on the website, take a screenshot, and then remove that. That's why this question of maintaining it for a period of 5 years, and as per the every company should have an archival policy of the information what they have uploaded on the website. These have been made mandated by the regulator. Earlier, that kind of malpractices also used to happen, that people used to just put it on the upload it on the website, take screenshots and all, and then keep it with you, remove the information. If anybody questions that, you can say always, look, I have uploaded it, but accidentally it might have got it removed. Now it is the responsibility of the compliance officer to ensure that the information what you have uploaded on the website is preserved for a minimum period of 5 years, and at the same point of time in alignment with your archival policy.
Again, Sudhakar, not only you also touched upon, and even Sanjay also touched upon, as far as the website is concerned, it is the responsibility of the company secretary to be all the way diligent. And as he rightly say, when the website design, etc., says something has got deleted, they are not going to be held responsible. Ultimately, the company secretary is going to be responsible.
So certainly, I think this also is very important. I mean, just the process part. 2-3 things which can be done just to make sure that all compliance officers continue to comply with that. First thing, without waiting or checking for the time limit, how much time this is to put on the website. When any information on any disclosure is made to the stock chain, immediately after that, the information should be put on the website. Number two, the periodic checking has to be done by the compliance officer, whether everything which is required to maintain is still there on the website or not, so that it takes care of the accidental deletion by any department of the company. Maybe once in 6 months or at least once in a year or so, the periodic checking is required.
In fact, in about a couple of months before, when I was addressing one forum about the role of the compliance officer and the company secretary, one gentleman who was participating, he was mentioning that company secretary is not a Superman. How can he ensure everything and anything? So the answer to that, what I have given there, and which may be also helpful to the participants here, is that yes, no doubt about it, company secretary is not a Superman, and he is not expected to do each and everything on himself. But company secretary is the person who is the responsibility has been assigned to him. Means what? He has to lay down a system as far as the compliances are concerned. At the same point of time, he need to review the compliance system as well as checks and balances from time to time. Nobody is asking that if the company secretary has to do everything and anything on himself only. He has to lay down that system properly, ensure that the compliance system is working. That means, individuals should not work, system should work. That is what the end objective is concerned. That is the reason why that compliance officer has been given that kind of a responsibility. And he has also been identified as the key managerial person. And he has been also assigned with some functions in both under the Companies Act as well as the listing regulations are concerned. In the listing regulations, company secretary, irrespective of his hierarchical position in the organization is concerned, he is considered as senior management as far as the listing regulations are concerned. So regulator has already insulated and empowered the company secretary as well as the compliance officer. It is up to him to exercise that, whatever the powers he have been given and whatever the duties he has been assigned with.
Absolutely correct.
So moving on to Regulation 47, wherein we talk about the advertisements in newspapers. So the listed entity shall publish the following information in the newspaper for financial results as specified in Regulation 33, along with any modified opinions or reservations, if any, expressed by the auditor, and also all the notices given to the shareholders by advertisement. The listed entity shall give a reference in the newspaper publication in subregulation 1 to link of the website of the listed entity and the stock exchanges where further details are available. The listed entity shall publish the information specified in subregulation 1 in the newspaper simultaneously with the submission of the same to the stock exchange. And it must be published in at least one English language national daily newspaper having circulation to most parts of the country, and in one daily newspaper published in the language of the region where the registered office of the listed entity is situated. So exceptions to this are for companies which are listed on the SME stock exchanges.
Here also one matter, the caution I want to give it is that when it is said that national daily newspaper, sometimes people put it in Sandhya Samachar or midday magazines. These are not considered as national newspapers. So one has to be very careful that by publishing your results in the Sandhya Samachar, normally I think if I'm not wrong, in Delhi, it used to be quite famous, that newspaper, Sandhya Samachar. And in Bombay, the midday magazine is very, very important. So you cannot put this thing that those are not considered as national dailies.
Yes.
Yes, Kanchan.
Yes, sir. So moving on to our last regulation, Regulation 48, which talks about the importance of accounting standards. And the listed entity shall comply with all the applicable and notified accounting standards from time to time. So following accounting standards is a mandate not just under the SEBI LODR, but also under the Companies Act. However, in cases of non-compliance, MCA takes action more under the Companies Act 2013. Although we see that LODR is harmonious with Companies Act, but the action from the MCA is undertaken under the Companies Act 2013 for non-compliance.
Not only accounting standards are followed by the company, and equally the statutory auditors have also checked and certified that company is actually adhering to accounting standards. In cases where the chartered accountants or statutory auditors, they relied upon the company's statements and we have followed the accounting standards certified, those instances also have come up actually. Equally, the statutory auditors were also held liable for penal actions. And
Right.
again, as we said in the beginning, it is not only the following the accounting standard, any departure in the accounting standard, any change of practice in the accounting standard, why it is not complied with, all those things also calls for necessary disclosure and explanation in the board report of the company.
Right. So with this, we've come to the end of my presentation, sir.
Let me run the check with the questions.
Yes, sir.
I see there are two questions are there. I don't know how far thing. One is actually any mistake in the results printed, how to correct it, and any due date.
See, any mistakes in the results are there, you have to give a corrigendum. And okay, if you have published the same newspaper where you have published it, you have to publish a corrigendum to that.
Correct.
But
That is
please
the
ensure
practice.
that, please ensure that the mistake should not be very, there is a difference between a mistake and a blunder. So please ensure mistake is only a mistake and it is not intentional. Sometimes, it should not happen that that mistake has been deliberately made and calling it as a mistake. That kind of things should not happen. And at the same point of time, suppose you intimate something to the stock exchanges and something else, you are publishing it and you call it as a mistake, how much it will be accepted by the regulator is a question mark, because normally what happens is whatever the things you are publishing it to the stock, disseminating to the stock exchanges, same copy you might be using it for your publication also. Why that mistake has happened, that one need to take care of that as well.
There's one more question thing. I think it is not relating to this regulation, but it is relating to stamp duty. Some of the state stamp duty provisions amended about the change in the name of the company also attracts stamp duty in the properties proposed to be recorded in the new name.
Sir, I must admit as far as my ignorance, as far as this question is concerned, I am not aware of that. As far as change of name of the company is concerned, it is going to attract any stamp duty. I'm not familiar with that. So in case you are aware of, okay, otherwise we may, give a pass to this question.
I am also not aware of that. I don't think this could be the thing. I don't know. Unless the question raiser has got something.
In fact, I'm also not aware because in my view, simply change of name of the company, I don't think there's any stamp duty implication. But in some states, this is there. I have not heard about that.
Yeah. Some entities publish the financial results and other matters in the English language in the vernacular newspaper. Where is the register office is situated? Is this correct practice or the matter has to be published in the vernacular language only? In fact, when I was a company secretary, I used to get translator. I used to publish in the vernacular language only. I think the requirement should be in the vernacular language because the people who are situated, they don't understand the English. So that has got to be in vernacular language. So publishing in the English in the vernacular language, I don't think is a right practice. What do you say, Sudhakar?
Yes, absolutely. In fact, is that some companies used to do that earlier, but subsequently it has been clarified that in the vernacular newspaper means even it should be in the vernacular language only. In fact, when I was working for Reliance that time, because we used to publish it in what's called a Marathi. So we used to ensure that, or Gujarati, wherever it is required. So that point of time, we used to ensure that apart from our publisher used to translate that and he used to send it back to us for our approval. And we used to have what's called as, the language experts to ensure that there is no kind of any errors creeping in that, because as company secretary or compliance officer, we were not equipped with that kind of this thing with us.
Yeah, it is expected to be published only in the vernacular language, not in the English.
Yeah, correct.
Is there any difference between the procedural postal ballot and e-voting in case of the listed company?
Yeah, that okay, that the postal ballot and e-voting are two different aspects. And okay, that for the postal ballot, the rules are different and the e-voting rules are different. The only thing is, as far as the postal ballot is to be, I mean, is there, it is to be conducted wherever listed entities are there. E-voting is mandatory for postal ballot also.
Yeah. That is all I think the questions are here. I don't think there is anything.
Yeah, now since Bala, that since we have about 20 minutes time, it is 12:38. So we have 22 minutes time is there. And since we are in the fag end of the year, if any participants wants to say anything about these webinars, which we have organized in the year 2023, and similarly what they are expecting from us in the year 2024, we may have some kind of a what's called as an okay idea about and with the feedback also. And so any of the participants, they may I request Saddam, please open both audio as well as video. People can open that and then they can speak. I request the speakers who are speaking, if they can also switch on their videos, we will have the privilege to view that person. Yeah, Pramod bhai. Saddam, I hope you have
Good afternoon to
opened
you.
the.
I will listen the entire conversation, and the subject what you have dealt in today is very unique and very informative for all the investors also, because there are many shareholders who have lost their equity certificates and many other things are there.
Pramod bhai, please go ahead
Yeah, it's okay.
with your audio.
Allowed નથી કરતો છું.
Okay, no problem, sir. And I have seen the face of all the four participants, and we are proud of presentation, moderation by him, and expert advice by Mr. Sudhakar ji, and also we are grateful to Mr. Gupta ji, also, and to Madam Kanchan. Kanchan means gold only, correct? All girls are gold only, correct? That's how it is. And we are proud of you, and I'm happy to inform you, Mr. All the panelists, that my one article on this appeared in the December issue of the Chartered Secretary. In the article, first article is mine only. It is on the prevention of money laundering and what action company secretary should take as a precaution. See. So at your leisure you can go through, and I'm very grateful to Atul Bhai and also to Dipti for this continued webinar which are going on, where sustainability is maintained. See, otherwise people do it for 2-3 days and then they forget. Here is a Saturday morning, means 11 o'clock. Mr. Sudhakar ji and our friend Mr. Balaji is always there. So we are proud of that, sir. And I'd like to encourage you to continue in knowledge sharing, because a lot of people and a lot of new students will benefit from the expected knowledge what we are giving in a very condensed capsule. That's it. Thank you, and have a great time. And Merry Christmas to all of you, and Happy New Year to 2024, sir.
Thank you, Pramod.
Thank you.
Thank you very much, Pramod bhai. In fact, for the benefit of the participants, Pramod bhai is also one of the doyens of the profession, and he was the past council member. And he must be, if I am not wrong, as far as the age is concerned, he is 85 years younger. And he ensured that to the large extent he attended all the meetings which held in Bombay physically. And he is having a great passion as far as the profession and its upliftment is concerned.
And sir, my
Thank you very
quotation
much,
of
Pramod bhai. God bless you. Thank you.
Yeah. So only one small thing I want to tell you about the age. There is a quotation of Mark Twain that we add life to the years and not years to the life. So I work on that basis, and every day morning God gives you one day extension, utilize well for you and for others.
Okay, I think okay, before some people are started leaving. In fact, some people have joined after I announced it in the beginning that on 30th we don't have any webinar. And because then okay, we have concluded the masterclass with this particular webinar, and then from 6th of January onwards, we are coming with a new webinar, the masterclass webinar series on the LLPs, limited liability partnerships. And so this is going to be helpful to especially budding company secretaries, and the same point of time to senior company secretaries also. Because with all due regards, I must say that the people who are having 15-20 years of experience, they might not be very confident about their knowledge levels as far as LLPs are concerned. I must admit that as far as my knowledge of the LLP is concerned, it is very negligible. I'm going to equip myself to prepare so that I can come as a panelist and can do some justice from 6th January onwards as far as LLPs are concerned. I request all the participants also to please go through that provisions, and then we can have some lively sessions. in case any participants wants to speak about.
Yeah, you can also give a suggestion for any new topic you wanted to take up and etc. and other thing and also.
Yeah, Mr. Malik, why can't you speak? You okay? You say good initiative, great, but you must speak, Mr. Malik.
So only one small suggestion, sir. All these webinars which have been done, they must be in the YouTube and all that. But so what I would suggest, if these are printed in a booklet form, it will be very useful to people to refer and to share with many others, sir. So and we can get sponsored for this good purpose. Any big large industrial house or somebody, we can sponsor it also.
Certainly, Pramod bhai, we took your feedback and we will think about that. Certainly.
Sure.
Yeah, I think Prof has raised their hand. Yes, Mr. Prof.
Good morning, sir. Actually, I am a practicing chartered accountant, but with the series of this webinar, I actually gain a lot of knowledge about LODR series. I just one suggestion from my side is the whatever the discussion is being had, I really appreciate your insights and the panelist insights, because that give us the practical view, like how practically these things will be implicated, because the regulation is on the one part and how the companies are dealing is on the completely different aspect. So I just wanted to emphasize on that, whatever the topics you may take, always have that practical aspects, so we can correlate with it.
Sure, Forum, that we will keep this in mind. Certainly, to a large extent, we do that. We also request whoever the
Yes.
panelists come, we also request them to share their experiences. Having
Yes,
said
yes.
that, in fact, if we are lying deficient anywhere, we will certainly improve upon.
No, you are I completely agree that you people are already doing it, and the major aspect that I liked about it is that practical aspect only. So
Okay.
I just wanted to inform you that you can just keep on doing this practical aspect area in your webinar.
Oh, great. Thank you, Forum. Thank you very much.
Yeah, and
Yes,
if
Mr.
you
Malik.
can share the soft copy of PPTs of the regulation or any gist of it, that will be grateful, because simultaneously we are not able to cope up with the regulation aspect and understanding the things.
You see that forum, as you know, that several times we have mentioned about this thing. Normally, we don't share the videos with, with in persons as such or the presentations. But certainly, all the videos are available on our website.
Okay.
Anytime any participant is not able to join or they want to repeatedly view that and then can understand that, all the webinars are available on our website. There is a Mehta Mehta YouTube is there. That there you can get all these things.
Okay.
One more thing I would like to add, Forum. So we send out a monthly newsletter prepared by us, Vedanam, which is a monthly newsletter also that goes out to everyone. So for all the registered people who attend our webinars also, we send out this monthly newsletter, mentioning all sorts of updates, amendments that are coming in. So that is one additional thing that we are doing besides conducting the webinars as well.
Okay, great. Then I need to enroll in that. Thank you so much.
Yes, Baliarjun.
Yes, so thank you. Excellent. I really call this as a KEC. These, it's a knowledge enriching capsule. Every, Saturday sometimes, it's now becoming like going to temple. Today is Vaikunta Ekadasi. But so it's the most important thing is, I don't know, maybe I passed in 89 or 90, but what happens is the passion to learn increases when you see the other side is able to not only able to infuse knowledge, but also the ability to be agile, people like Professor Bala or even Mr. Sudhakar, I think it's very, very important. Good. I think I am mostly at an unless something emergency or whatever. I would say that probably we should, this will be very good. Companies Act will be great, and LLP will be great. A little bit more on ESG and BRSR we can cover, like we discussed, Sudhakar, we can see on that. And I think also probably cover a bit on mediation and also on the data privacy laws. And since I have also been away for 17, 18 years in Europe and Singapore and other part, I think data privacy is something which is very critical. I know, so important to cover, and it will be nice to hear. Last but not least is a topic which is very close to heart, is about contracting. Now, certain terms and conditions of contract is very critical, not only for a legal, but also from a company secretary perspective, more to look at, and especially companies which are into project management, what do they say, what kind of consequential damages, is there a loss of, so these are the topics also can cover, because sometimes when you go beyond Companies Act or LODR, the enthusiasm also for a session is a little bit different in this. So this is just my view, and thank you all for you are doing a wonderful job. I would say once in a while do a in person. You can charge a small amount, and we can. What happens is seeing somebody, talking to them creates a kind of closeness to heart, and it's very important to also. And if you want to run something in Pune, we will help you. Bala sir and me will help you.
Thanks
So,
for
Mr.
your
Malik,
gem.
in fact, say you may appreciate. I will take your last point first that you said. If it is in person, that is one of the reasons why at Mehta and Mehta, we do certain area. I mean, locations we are doing. Physical meetings also wherever I travel. You know that very well that about in the beginning of this year, if I am not wrong, I think March or April, when I was in Pune, we had one
Yeah.
such meeting we have organized, and wherein I dealt with the topic of listing regulations, if I am not wrong. Sorry,
Yes, sir.
insider
Yes,
trading
sir.
regulations.
Yeah.
Okay. Similarly, about a fortnight before I was in Delhi, there we have organized one such event. Prior to that, in Gurgaon, we have organized such event, and a few months before, we did it in Calcutta, and in January we are going to do it in Bangalore. So these are the places wherever I am traveling, okay, that we are making it a point that to have this kind of events wherein we are inviting the people without any free of cost, just for the. I mean, in fact, Atul Bhai has this passion of dissemination of the knowledge and to do something to to the fraternity is concerned. His view is that, by the way we do, I mean, the companies are to discharge the corporate social responsibility. The professional firms have to discharge the professional social responsibility. So in that PSR, this thing, this is what we are, this initiative which we have taken. In fact, Mr. Malik, you were there yesterday at that IOD conference, day before yesterday, I think I met you there in the IOD conference of Bombay. In fact, one gentleman who was from Tamil Nadu, that gentleman was telling me he also is a regular participant to all our webinars. And he exactly used the word what you have used it, like going to a temple. And he also told me that, Mr. Sudhakar, please take a note that without taking a bath, I never attend your webinars. That kind of. I was really
Purification,
thrilled, and I was
purification
really
at its
thrilled
best.
when the people say like this. He says that every day, every Saturday morning, I complete my puja, everything I finish it, and before by about 10:45, I sit in front of the laptop. That's what he has mentioned it.
He
In
said
fact,
it,
I
I
don't
didn't
want to
say it.
reveal.
He said it, I didn't have the guts to say that after the puja I come and sit.
So, Mr. Malik, I also like your comment.
And your one more session of yours as far as the ESG is concerned. In fact, for the benefit of the participants, let me say that some of you might be knowing. In addition to the Saturday webinars during the year 2023, we have organized a series of webinars on corporate social responsibility. Almost, if I am not wrong, 11 to 12 webinars we have organized on corporate social responsibility, a masterclass on that, wherein we have also involved the NGOs who are connected with the corporate social responsibility. And in fact, every webinar of that, the attendance used to be about 600 to 800 people used to be there. Of course, considering that kind of an attendance, we have not attended anybody to allow to speak like this. But yes, they used to put their queries along in the chat box, and we used to definitely give the clarification. And we have also, as a part of that CSR, this thing, we have also covered about the social stock exchanges on that. And again, the same thing, I think if I'm not wrong, 2, 3 webinars we have discussed about the social stock exchange, wherein we have also invited the BSc representative as far who is heading the social stock exchanges is concerned. Now, as far as the ESG is concerned, I thought I will put something up to my sleeve, but since you have preempted me to speak about that, we are also going to start one ESG series, which is separate from the Saturday webinars. We will be conducting mostly on Thursdays, and that ESG webinars very soon we are going to announce that also. We have that idea to organize a separate series of ESG, because ESG, as you know, that it is a big ocean. We need to structure that properly. We need to have good panelists for that. We are working on that. And most likely from January onwards, we will be able to do that. That will be not a weekly webinar, that will be a fortnightly webinars.
Okay.
A lot of things are there in store for our participants.
Thank you, sir.
So, Mr. Malik, I really like your comment about you were saying that this knowledge session are like going to temple, because I think in today's world, I mean, there's no greater worship than acquiring knowledge and imparting knowledge. I think both of, I mean, if you see we as panelists and you as audience, we both are doing the same thing. So this is really good. And about your topics like, for example, CSR has been covered by Mr. Sudhakar. About the data privacy. Data privacy, yeah, this is very, very important topic. And maybe we can have some good speakers. I mean, we as company secretary may not be the right people to impart knowledge in this topic, but definitely we'll look for experts on this topic who can do justice with the job of talking to the audience and, telling the laws surrounding that, GDPR regulation, data privacy, and all other things.
Yeah, okay. I can refer one to Mr. Sudhakar. There is one in the north, I think in Delhi. He runs even a college on data privacy. This thing I will definitely do. I attended one of his conference. So thank you. Thanks for giving the opportunity and good luck. We will all here to support you all. We will do our best in 2024.
Thank you very much, Mallikarjun, for your good words. When you touched upon the personal data protection, I think since you have traveled abroad and other things, I also happened to be in some of the places where I visited, that data protection has been very importantly recognized and regulated in many other countries. As far as our country is concerned, I think it is only very recently this has come. In fact, if I'm not mistaken, somewhere in the middle of 2023, the Parliament has passed the Digital Personal Data Protection Act, which has actually come. We'll have to go a long way on this, and it is a good idea to have a seminar on this. As Sanjay puts it, we'll have to get an expert to understand the insecurities, etc., and other things, and all those things. That is there. Thank you. Thanks a lot.
Thank you.
Suresh, I have seen your suggestion, and why can't you also speak? And in fact, instead of putting a message, Mr. Suresh, Dad, would you like to say something?
No, I'm audible.
Yeah, you are audible now. Yes.
In continuation of Malikji, what truly mentioned that for like us as a professional, this forum is truly a temple to enrich our professional knowledge by way of sharing to each other. And whatever the topics which we have taken during this 2023, these all are the topics which are not required more clarification, understanding for implementation and from governance point of view. So I appreciate to Mehta and Mehta for taking this lead. I am taking another way that this is not just only a by profession, but it is a kind of a CSR program by which now enhancing the knowledge of all the professionals, not only of our institute, but who are participating from other domain, they are also benefited. Now the message is only the what knowledge shared during the 2023. No, it is our responsibility also as a corporate officers or professionals to how to implement in our day-to-day life and ensure that whatever learnings we have to transform in our businesses also. I was also looking, we always talk for the parameters, what now clarifications we also have about the compliances. I'm also looking beyond that for corporate governance, which is ultimately the object of the regulators only to comply in letter and spirit. So there is no corporate values, corporate governance, and corporate reputation. So this is one of the most important area where now we are looking. By regulation, only we can comply, but in practice, reality, how we are going to do and what is our intention and what is the intention of the regulators. Those things are most important. So by having this kind of forum, we are very much encouraged how to implement the regulations, in what form manner now we have an interpretation for building the reputation, enhancing the value or corporate values of our organization wherever we are working. So I'm thankful to entire team who are on the back of this organizing this program from Mehta and Mehta company also. One area which we can consider also, this is a climate change, which is a most challenging, particularly from the risk management point of view also. When we have a global presence of the various businesses, that will help us in case if we are able to do it, that would be. So Bala sir and sir, all matters which we have shared during the 2023, it's greatly helped us to us. Thank you once
Thank you
again.
very much, Suresh.
And I also thank to all the participants who have also joined. And I also tried. This is for us, morning breakfast is not so important, but this program is very important for me, so that I should always try to join this program without fail, barring some commitment otherwise. So thank you once again to all, sir.
Great.
Thanks a
Thank you
lot.
very
Thanks
much,
a lot,
Mr.
Suresh.
Suresh. Anyone else? And we are already at 1 o'clock. If any 1 or 2 people are there, otherwise we may wind up the session for today. Good. I don't think anyone else wants to explain this thing. So
I will say a last word.
yes, Bala, please go ahead.
You know, it is a very pleasure for me to look forward this seminar every Saturday, number one. Number two, I always believe, continue to believe, learning doesn't have any age. I come these programs. In the process, I also get to know a lot of learnings in this. It keeps adding me knowledge. And above all, one more important thing, which I would like to share with all of you. I feel 25 years younger than what I am when I'm sitting in this room. That's it. Because it is very nice to interact with the people, especially with the youngsters, especially with the panelists, learned people who are coming with the rich experiences, etc. There are a lot of things to learn in this. If you really want to do, which is really, really helping me, I would tell that. That's all. Thank you.
Yeah. Great. So this is in fact, the objective of the organizing these webinars also is the same thing. And in fact, when I got associated with Mehta Mehta on 1st of January 2023, that time I have been asked by if you can be also a regular panelist without fail, and also give your support to these webinars. So I thought, yes, I was passionately attached as far as the knowledge dissemination is concerned. So I took the responsibility for that. And I also pushed a lot of our partners to come as presenters, because when a person is making the presentation, he has to do lots of research as far as the topic is concerned. And once you make a presentation, you will never forget that also. So this is going to be helpful both internally as well as externally also. And at the same point of time, wherever I travel, the kind of feedback what we get, that everyone is getting benefited with this. That's what our endeavor also. With the kind of feedback what we have received, we are immensely delighted to and got inspired to something more good than what we did in 2023, which we are going to do it in 2024. Thanks very much once again to every one of you for your active participation in these webinars. Look forward to meet you in 2024. We take this opportunity to wish you all on behalf of Mehta and Mehta, as well as my personal behalf, to wish you all a very Merry Christmas, as well as a happy and prosperous New Year. God bless you all. Thank you very much.
Maybe I have Swami, with your permission, I would also like to add.
Yes, Sanjay, please go ahead.
So, this is my first opportunity to be panelist on Mehta and Mehta webinars, and I'm thankful to Mr. Sudhakar that he offered me this opportunity. And I can't tell you, I can't express my feelings proper words that how happy I am to be panelist imparting little knowledge I have. And secondly, I am also seeing the enthusiasm of people who are regularly attending these kind of webinars. What is their feeling towards these kind of webinars? Because now I have the 100% firm view. The Mehta and Mehta is doing a great job of doing this kind of webinars without any self-interest, just in the interest of fraternity of our members. So that's a great initiative. And this is a privilege if we can invite it for this kind of webinars in the future also. And maybe I'll do justice to my job. Secondly, thank you all. Thank you very much, all the audiences who devoted their time to attend to these webinars. And wish you all a very happy Christmas, a very happy New Year. Thank you so much.
Kanchan, you also say that. I was about to tell you that only. Yes.
Yeah, thank
Yes,
you.
sir. So, right from when we started off conducting our webinars, sir, I think we as partners also have come a long way because as soon as we all receive a call from you, sir, from Sudhakar, sir, that you are going to give the presentation. So we start having some sleepless nights. And there's a lot of research, there's a lot of learning, and I think we all also are growing in terms of sharing and caring while we are doing these webinars every week. And there's a camaraderie that we are developing amongst ourselves also, and in terms of sharing the knowledge with the fraternity at large. So thank you so much, sir, for giving this opportunity to me personally, because I think I'm going to do a lot more in 2024 than I have done in 2023. I promise to keep growing and learning more. Thank you so much, sir. Thank you, Bala, sir. Thank you, Sudhakar, sir.
Great, Kanchan. You were there earlier also in this program. You made some presentation there earlier also. That is one. And second thing is, you have done an excellent job. You have put everything very nicely. Wonderful presentation you have done. You have elaborately very nice also. Thanks a lot. I'm sure you'll do a lot many things good. I'm happy about it.
Thank you, sir.
Wish you all a Merry Christmas and a Happy New Year. That's all. We meet in the new year.
So before we conclude, I must also acknowledge the support given by Disha for organizing these webinars, and she is the backbone of ours. She's always behind the curtains, and she is the one who coordinates with the panelists, and she is the one who coordinates with the presenters, take the entire responsibility. At the same point of time, our Mr. Saddam, who is the technical person who ensures that without any kind of technical snacks, the things are happening smoothly. And he keeps also that what is the attendance, and from we got the entire statistics as far as the participants are concerned, so that we will be able to ensure that we are reaching to everyone and anyone. And last but not the least, I must also acknowledge the initiative taken by our founder partners, both Atul Bhai and Dipti Bhai, that for organizing these kind of things. And because of their initiative only, we are all here today and we could successfully organizing these webinars. Thanks very much once again to every one of you. God bless. That's all for today. Thank you.